Hello and welcome to this two-part series on construction arbitration in India on Legally Speaking with Tarun Nangia. In both the two parts, we will discuss at the peripheral level to start with on how construction arbitration has been conducted in India, what is the scope of this industry, specifically when we know that a large percentage of our GDP comes from this industry, which is construction and infrastructure. And even in this budget, which Finance Minister Nirmala Sitharaman presented, a huge chunk has been allotted to the infrastructure sector. And that is why, of course, we also know that there will be a lot of arbitration going forward in this sector because disputes are a natural fallout of any work that goes on. But the key to any country's growth is faster dispute resolution, which arbitration provides. It has emerged as a favorite medium of business to swiftly and fastly resolve their disputes and contribute to nation growth. For this show, we've got a diverse panel. May I introduce you to Justice Arjun Kumar Sikri, who is a familiar face on Legally Speaking. He presides over the show today. Welcome, sir, and thank you for your time. And may I welcome Senior Advocate Ratan K. Singh. As you all know, he is an international member of Keating Chambers, London. Mr. Ratan Singh is also head of the Society of Construction Law UK's India chapter. May I welcome Shashank, Advocate Shashank Garg. He's an arguing counsel at the Delhi High Court, Supreme Court. Neha Nagpal also joins us from the first time. She runs her own law firm. Neha Nagpal, welcome to Legally Speaking. May I also welcome Manmeet Kaur. She joins us for the first time on Legally Speaking. Manmeet Kaur, welcome. You're with Karanjawala and Company. You also undertake a lot of arbitrations on their behalf. But as we start the show, may I request Justice Sikri in about 2.5, 3 minutes to lay the ground of how construction arbitration has been happening in this country since the past many years and what shape it is now taking in the next 2-3 minutes. So if you could please share these things with us.
Thank you, Tarun. I first congratulate you for organizing this discussion. It is not it doesn't relate to arbitration in general, but in respect of construction arbitration in particular. And I would say, and the other panelists would vouch for that, because we know Mr. Ratan Singh is expert in construction arbitration. Shashank also has a very vast experience, and equally Manmeet and Neha Nagpal. Number one, insofar as arbitration matters are concerned, construction disputes assume significant portion of that. I think maybe of all kinds of arbitrations which go on, whether it is, and it is not only domestic arbitration, whether it's domestic arbitration or international arbitration, maybe 60% of that would be only relating to construction and these kinds of projects which are there. And as you rightly point out, that in view of the fact that third world countries and including India, which is developing country, and of course not only developing country in the sense that yes, we have not reached the stage of developed country, but then we occupy today a prominent position in international economy as far as India is concerned in terms of our GDP, etc. But then there are so many projects which are launched by the government or even private sector, etc., which are underway, and therefore the construction industry occupy a very prominent field. And construction is one activity, as you rightly said, which is very important for and creation of infrastructure, etc., very important for any economy as well. So therefore we need to have, and that is why there is a talk, whether it is national highways are concerned or other projects of national importance are concerned. And but what is peculiar as far as these arbitrations are concerned, that means arbitration means a dispute has arisen. So sometimes the disputes arise even when the contract is or the project is under execution. So what becomes important is, and that is, although that may apply to all kinds of arbitrations, But in particular construction cases and where the big projects are under construction, that even when the disputes arise, we have to ensure that the dispute is settled as early as possible with the least, cost effect, and it doesn't affect the project or the work which is going on. Because if that is hampered in the meantime, and that may happen in certain cases where, say, contract with some particular contractor is terminated and it is to be awarded afresh. But I'm not talking of that. But then there are situations where even for ongoing arbitration, the disputes do arise. But the parties want that the relationship continues, and the dispute may be settled amicably and relationship continues. And for this reason, many times, even before arbitration, there are steps taken for mediation or negotiations, etc. But even when those fail and it comes to arbitration, as I said, that speedily, resolution of these disputes becomes paramount insofar as these construction arbitrations are concerned. Then third thing on which we will develop, because I'm just saying, as you said, introduction, is that there are certain peculiar features in contrast with other kinds of arbitration, peculiar features insofar as construction arbitrations are concerned. Because although in most of the cases you'll find the contract clauses say the time is the essence of the contract, it is to be completed within such and such period, which in practice doesn't happen. They are delayed for one reason or the other. There are so many reasons for which delay may be attributed to the contractor, they may be attributed to the employer, and so these things happen. But then in the arbitration process, and when this is so, the delay, on whose part delay is, how much delay is to be attributed to contractor, how much, and we have the terminology called overlapping delays, critical delays, etc., on the basis of which compensation or damages would depend, or if the employer wants to impose liquidated damages, that will depend. And in the process, how the experts should deal with these delays, and then the quantum, again, experts, how they should deal with these days. So these are some of the very peculiar aspects of construction arbitration, and which need to be taken care of by the practitioners as well as the parties and even the arbitrators. Those would be my introductory comments.
Thank you, sir, for your introductory comment. I'll go to Senior Advocate Ratan K. Singh. See, today I was moderating an earlier panel earlier in the day. A group of promoters said that you will see billions of dollars being poured into infrastructure in India, but India can only be a successfully growing country if dispute resolution end is sorted out. We need faster dispute resolution. And in this country, arbitration is one of those fastest routes. So keeping that in mind, I want you to give your introductory comment.
Thank you, Tarun. Thank you for a kind introduction. And I must say in the very beginning, it is always a pleasure to have Miller Justice Sikri on the panel. Wherever and whenever I have been in panel with Miller Justice Sikri, Miller Justice Sikri's ability to summarize the whole subject is really infectious. So what I'm going to do is, I'm going to give you slightly a different perspective of this, which directly deals with the question which you have posed. As Miller Justice Sikri said, construction arbitration is different from commercial arbitration. This awareness has to come. Miller Justice Sikri gave you one statistics, that is that around 60% of mid-size and large-size arbitrations which we have in India, 60% are construction arbitration. ICC report last year or last year, ICC's report says 40% of their work caseload is construction, engineering, and energy. Now, coming back to your question, I must say this, that traditionally, arbitration has been the preferred mode of dispute resolution for construction industry. Therefore, this expectation, and therefore this question to you, and therefore your question to us. Expectation of the parties from construction industry are grounded in their business relationship, and they expect, therefore, fair, just, and commercially sound decision. They do not want, I would say, court justice. What they want is arbitral justice, which according to them, as per them, or for them, is different from court justice. Paul Hardman versus Arc Power and Light was a case in the US federal court where US federal court judge had observed that construction contracts are separate breed of animals. People who are aware of the construction law and construction arbitration, they would all agree that construction law and construction arbitration both are different breed of animals. 3 years back, I was speaking in a conference in Singapore, and I was asked 3 questions. First, do you teach construction law in your country to law schools and law students? Second question was, do you have construction legislations in India? And third question was, do you have construction courts or specialized technology and construction courts like you have in different jurisdictions? And ladies and gentlemen, answer to all the 3 was in negative. If we really want to have better construction arbitration ecosystem in India, what we need to have is better pool of construction lawyers, construction arbitrators. And how to go about it? For that, what you need to do is you need to teach your law students and engineering students about construction law and create awareness amongst the lawyers as well as the arbitrators about peculiarities of construction arbitration. Justice Sikri talked about peculiarities of construction arbitration. I'll add few more. In fact, 2019 International Arbitration Survey conducted by Queen and Mary identified 5 most defining features of international construction arbitration. 1, these are factually and technically complex. It is very different from typical commercial arbitration. Large amount of evidence, documentary and oral. 5 days back, I got a case. I was briefed in a matter where it relates to a big, very popular expressway, which became very popular for some region. Now, there the documents which have been brought on my table are around 25,000. So, construction arbitrations are fact heavy, document heavy, issues heavy, multiple claims and multiple parties. Construction arbitrations are not one arbitration. Let us understand that there are multiple arbitrations in one arbitration. When I talk about 25,000 documents, there are arbitrations where you have documents running into millions because these projects are going on for years and every day thousands of documents are produced. So managing those documents, digesting those documents, digesting the chronology of events, so that is something, and the issues are again multiple, and large amount always remain at stake. So what I would say is it is peculiar. See, I'll tell you what. In UK, you have Housing Grant Regularization Act, that is called Construction Act. Malaysia, which was the latest to have the security of payment legislation, which deals with construction industry and construction dispute, is called CEPA. New Zealand has it, Australia has it, Singapore has it, multiple states in US has it. We don't have construction law. We don't teach construction act, construction legislations. We do not have technology and construction court. We do not. So that is where we have to start with if we really want to take it forward and have a better ecosystem for construction arbitration.
It's a good intervention by you, Senior Advocate Ratan Singh. When we are going to spend something like $300 billion on infrastructure creation in India, which in my view is about 24 lakh crores, I think this ecosystem will only be an enabler in this process, which is needed. And I think such discussions anyway take forward such ideation. I will go across to Manmeet Kaur. Manmeet, in your law firm, you undertake such arbitrations. Could you share with us the complexities involved and whether it's at nascent stage in India? Where are we in that, in a sense, where are we headed in this area, or is there much to be wanted?
So, Tarun, I will start with from where Ratan sir has left, which is the anatomy of the construction arbitration is entirely different as far as from the regular arbitrations or a regular company disputes. The construction arbitrations are more of a technical nature and a factual driven arbitrations, which are usually happen at the end of a contract period. Sometimes there is a prolongation of the contract period. Sometimes there is a quality issues. Sometimes there is a quantity issues, or sometimes you can say there is a designs issues. So the complex nature which will run into a thousands of pages, and as sir pointed out rightly, there is no specific code designated to undertake such kind of a dispute. So rightly said by Ratan sir, the arbitration come to the recuse of such kind of a dispute. But now to tackle such kind of so for example, how to quantify a damages. So but the work contract is an item rate contract. So you have to quantify the damages. So the damages have to be quantified as per the technical specification given in the contract or executed by the contractor at the work site, and who has signed off by the engineers. So when you have to have a resolution of such kind of a dispute, I do feel, given the nature, cause as today we stand, it's the second highest growing factor after agriculture, which add up to Indian economy growth. After agriculture, I think construction is the second highest, and we expect that Indian construction will in 2025 will go up to the third highest sector, construction sector. So given that nature of a contract where a lot of FDI investments are coming, we are looking at to have a NHI contracts are very, voluminous contract to bridge the modern infrastructure. To deal with these kind of integrities, we need to have an expert panel arbitrators, or we need to have an institutional arbitrations. So for example, if there is an escalation during the contract got prolonged for any reason, the actual duration was for a 2 year, but some clearances from the government, some XYZ factor took it longer than 2 years. Then there is an escalation in the steel prices, there is an escalation on the cement prices, and there will be other factors which will also taken into a consideration. So how to quantify those? The legal, as a lawyer, a basic arbitration, ad hoc arbitrations, we can only understand from the document, which will run into 10,000, 20,000 pages. But I do feel there is a need of an institutional arbitration, especially where we have an expert who primarily deal with the construction contract, somebody like who has retired as in a CPWD chief, or somebody who's been on a technical position for a longer time to assist the judicial before reaching into, I would say, a judgment on a judicial or a legal angle, to assist the tribunal, or an expert appointment in these kind of an arbitrations is a need of the hour.
Point well taken. I'll take this to Shashank. Shashank, the role of experts as Manmeet raised. If you could delve into that, is that already happening? Do we have experts assisting, presiding arbitrators and the like? And secondly, the expectations of industry, Shashank, from the arbitration process, because all we hear is we want quicker dispute resolution. We can't pay back the banks. We can't pay salaries because money is stuck. And we see, I mean, in NHI contracts, of course, we see that. But in others, in also general, there is some kind of delay that happens. If you could look at all of that holistically and give your answer.
Yeah, thank you, Tarun. First of all, I must thank Justice Sikri for that beautiful laying of the ground for the entire topic, and Mr. Ratan Singh was given detailed introduction. But the point that you have raised, and I would like to answer with the first part of it, that is the role of experts. Role of experts, the Arbitration Act itself provides for experts can be appointed by the tribunal, expert can be appointed by the parties. Increasingly, you will see in domestic arbitration, this trend is coming in. It was obviously there in international arbitration. In large-scale arbitration, the cost of expert was marginal. In smaller disputes and mid-sized dispute, the domestic arbitration circuit was feeling the pinch of hiring an expert. They just could not really see the value of bringing a quantum or a delay expert in like 5-7 years ago. But now increasingly, and I'm sure all the panelists would agree with me, any construction infrastructure dispute which has that sort of complexities, and if the tribunal is not equipped to handle or is not experienced enough to handle a construction dispute having so many layers, so many complex layers, there the role of expert is, I think, imminent. And mostly, in my experience, parties do prefer to bring in subject matter experts. And if not, I've seen increasingly, if not in India, at least in Asia, I've seen the tribunals are bringing experts if parties are not choosing subject matter experts for which the tribunal needs assistance. The second aspect is expectation of the industry. Now, I think there is a lot of preaching, but not followed by the practice. I hear general counsels come in conferences and then they blast retired judges, say that all the entire arbitration work has been, taken over by retired judges and etc. etc. The costs are going high, but really speaking, who's appointing the arbitrator? You're yourself appointing the arbitrator. They have been performing very well for decades together. If there is an issue, then you have to address. The industry has to address. I'll give you a very small anecdote, and this will give you the entire perspective of what I'm trying to say. This was for a very complex construction dispute, which was before a three-member tribunal. And the presiding arbitrator, I was to go and submit some documents. My client had sent a team of IITians to explain the dispute over a week. So I just casually asked the presiding arbitrator, it has taken us a week, 10 days just to get into the dispute, and 3 engineers were sent by the client. How do you get grasp of all these subjects so quickly? And his answer was that, frankly, Shashank, we don't. But being a judge for so many years, we know which side is presenting better. Now, that's what you don't want in a super complex dispute. You obviously want a set of arbitrators, and it's even former judges have been doing so very well. You may have a mix of a tribunal where you have a CPWD retired engineer or a technical arbitrator and 2 retired judges. All of that mix has to be seen by the parties, but you can't blame the tribunal later for a poor choice that you make at the beginning. And I think one of the discussions that we had in the past was also that appointment of arbitrator therefore becomes of paramount importance. In disputes like construction arbitration, it is even more so.
Point well taken, Shashank. I will go to Neha Nagpal for her intervention on this issue, and also how she sees that this whole practice growing in the coming years.
Thank you, Tarun. Thank you, Justice Sikri and Ratan sir, for your valuable inputs. Tarun, that's a very pertinent question, actually. And I think that, a slight digression, but I feel one of the reasons that the Insolvency Act was introduced was to create an ecosystem where companies that were stuck financially or were in a financial trap could be laid to rest or could be given a pump or new sort of lease of life in a time efficient manner. And I think that it is time to address that issue even with the construction industry, because a lot of large, I represent a few construction infrastructure companies, and most of them are grappling with payments that they have to receive from various employers, contract employers. And they are literally choking now because their matters are stuck in some court or some appeal, and consequently they are either being voluntarily going into insolvency or they are being taken into insolvency. So that needs to sort of, and they have developed national assets. They have contributed to development of roads and highways. So I think it's very important to save these giants and to promote this sector, because it is, as Manmeet also mentioned, by 2025 it is going to be the second most relevant sector in the country. To promote, create education awareness, and start training across the board at law schools, even as young professionals, and even provide a database to arbitrators through the construction arbitration sort of industry that is not industry, the construction industry arbitration council that was set up in, I think, 2006. Through that, maybe disseminate more information, gather more steam on that, because it is highly relevant that now is the time if one wants to see the seamless growth in this sector.
Okay, point well taken. I'll go to Justice Sikri for drawing the first part to a close. In part two, we'll take this issue further. So your closing comments on the interventions made today.
I think all the speakers have spoken so well and given different dimensions and laid, their structure, created that structure, infrastructure on the foundation which I laid. And you see, and all these aspects have to be kept in mind. As I said, these are unique, a different kind of arbitration or even dispute resolution. So what I feel is, and as I said in the beginning also, these are the, disputes which have to be resolved as soon as possible. And Neha rightly mentioned that if these are not resolved and since the payments involved are very, very large, I've seen the, where the stakes or the claims will run into thousands of crores. So therefore, if there are legitimate payments which are not given in time, and because of that, they are led to bankruptcy, and which he rightly remarked. And I'm reminded of one very interesting anecdote which somebody said, that if the delay takes place in these arbitrations or dispute resolution, the person who ultimately wins, the party, winner is the loser and loser is bankrupt. So even winner doesn't gain ultimately. So therefore, we have to have, a different, these cases are to be looked into, or it has to be seen from different prisms. We have to have a different yardstick. We have to have different methods of resolving it. And Ratan, I would say, made very, very pertinent comments about the teaching of construction law, because here normally we know only the Arbitration Act, somebody, and which would be totally general, but it is a specialized branch. And they have mentioned about pages, if I may say so, 20,000, 30,000 pages. I am doing few arbitrations where the pages are in lakhs of pages which are filed by the parties. Of course, out of these, sometimes what happens, a particular document is to be filed, even one clause is to be seen, or two paragraphs have to be seen, total document has to be filed, which may run into 50 pages. But still, the work may be tremendous. So therefore, how arbitrators should know as to how to conduct it, what we call CMC, the case management conference, and to bring it on rail from very beginning. They have to have a grip of the over the matter, as Shashank rightly pointed out about the importance of the experts. And he is right that now I see, even 3 years ago when I started this arbitration work after my demitting the office, in the beginning, I found few cases where the delay was not even analyzed properly. Both parties just blamed each other. But then delay analysis, how much it takes place, how much it is critical, etc., there was no such thing. But now experts are coming. Likewise, experts are needed on quantum also. But more importantly, I think the message which we take today, and what Ratan said, that it has to be taught, this specialized branch of law, in law schools. We have to have some law, special law on construction, and we have to have construction courts for that purpose.
So the takeaway also, as I can see what Justice Sikri said in his closing, is construction courts in India. I think we should all talk about it. India needs construction courts. If $300 billion are going in creating infrastructure, surely a couple of 100 crores can go into creating modern court complexes which will house these construction courts. But this is an issue for another day. I would like to thank Justice Sikri for joining me. Also, Senior Advocate Ratan Singh, Manmeet Kaur from Karanjawala and Company, Neha Nagpal from Nagpal and Associates, Advocate Shashankar. Appreciate your taking out time and joining us for this very important issue, which is key for India, which is key for our businessmen, and which is key for driving investment in India. Because as someone said, India will get a lot of investment provided we can promise faster, quicker, and efficient dispute resolution via arbitration. If we can provide this, then of course there is no limit to the amount of money India can attract. But that's it for now, folks. Thank you so much for joining. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.